originalist and a textualist. So let me ask you, the Emoluments Clause provides that no person holding public office shall accept any present of any kind, whatever, from any king, prince, or foreign state. Do you believe the language in the Emoluments Clause that says any present of any kind, whatever, means any present of any kind, whatever?
Senator, you are quoting the text of the Emoluments Clause, and I cannot dispute with the text of the Emoluments Clause.
So it would apply to any present, including an airplane?
It would apply to the president, I believe, your Senator.
And I take it as an originalist, you would accept that the founders would have never subscribed to the idea that a president in their time could have accepted a multi-$100 million gift from a foreign state?
Senator, the premise of your question implicates live issues in the public and pursuant to the canons of judicial ethics.
Well, let me just ask you, would the founders have believed that if a president received 100 camels from a foreign state, that that was an emolument?
Senator, it's difficult to answer that question in the
Is it, though, as
abstract.
an originalist? Isn't it pretty simple? You've got the clear language of the Constitution.
Senator, one has to look at the language, but also the history surrounding the Emoluments Clause in order to discern the
I am
meaning of
looking
it.
at the history. Let me move on to another question. As an originalist, do you believe that the Obergefell versus Hodges decision affirming constitutional right to same-sex marriage, was that wrongly decided?
Senator, Obergefell versus Hodges is binding precedent of the Supreme Court.
I'm aware of that. Do you believe it was wrongly decided?
Senator, as a circuit judge, I would be bound to
Oh,
follow
I understand that, but that's not responsive to my question. Had you been on the Court of Appeals prior to that decision, would you have decided the case that way?
Senator, prior to Obergefell versus Hodges, there was a prior Supreme Court case addressing the issue, and I would have followed that case.
Well, would you have reached the same conclusion as the Supreme Court in Obergefell?
Senator, I would have followed binding precedent.
You're not
prior
answering
to
my question. Would you have reached the same conclusion?
Senator, the conclusions that the two precedents reached were potentially in conflict, and I would have to follow the precedent that...
So you can't tell us at this point whether you would have reached the same conclusion as the Supreme Court in Obergefell. So let me ask you about the Supreme Court's decision in Lawrence affirming a constitutional right to be intimate among same-sex couples. Do you believe that was wrongly decided?
Senator, Lawrence versus Texas is a binding precedent of the Supreme
Again,
Court.
I'm aware of
and I would be
that, but I'm
bound by
asking
that
you whether
precedent.
you believe that was rightly decided or wrongly decided.
Senator, you're asking about my personal views.
No, I'm
and as a
asking you about your
nominee-
legal views. I'm asking about your legal views. Let me ask you about another case. Do you believe that Loving versus Virginia, which affirmed an interracial couple's right to marry, was that wrongly decided?
Senator, my wife and I are an interracial couple, and so if that case were wrongly decided, I would be in big trouble.
Okay, so you do agree with the reasoning of that case, and you're willing to say that. I appreciate that. But you're unwilling to say that you agree that Obergefell and Lawrence were correctly decided. Why is that?
Senator, again, those decisions are binding precedent of the Supreme Court, and I would be
No,
bound
I'm
to
aware of
follow.
that. So is Loving. And you're willing to tell us that you believe Loving was correctly decided, but you're not willing to say the other decisions were correctly decided. That seems less originalist and more situational. Let me ask you this about your role in the brief in Moore versus Harper. This was a case involving the discredited independent state legislature theory, which would allow a state legislature, even in the absence of a governor's signature, to effectively overturn an election. Do you believe that the Supreme Court wrongly decided Moore v. Harper when it rejected your view?
Senator, again, Moore v. Harper is binding precedent of the Supreme Court. and
Yeah, no,
although-
I get that, but you're still not answering my question. So let me ask you a different way. If a state legislature decided after an election to pass a bill, even in the absence of a governor signing it, to throw out absentee ballots that were mailed prior to the election but arrived after the election, would it be your view that a state Supreme Court or federal court would have to allow the legislature to overturn the election, would be powerless to correct that effort to overturn a free and fair election?
Senator, Moore versus Harper states that state courts can review what the state legislatures have passed as a matter of the
No,
Constitution.
I'm aware of that. And my concern, though, is that your unwillingness to embrace the reasoning of these decisions means that where there is room, and there is room in all of these decisions, and most particularly Moore v. Harper, for you as a court of appeals judge to narrow these decisions, it sounds like you'll take that opportunity to narrow those rights. And in the case of Moore, which I agree with Judge Ledick, the most important case to our democracy in a century, narrowing that decision means empowering state legislatures to overturn election results, and I cannot imagine a more dangerous idea on the bench.
If you care about democracy, accountability, and the rule of law, make sure you like and subscribe to Crossline Politics so we can keep bringing you the truth behind these hearings. Watching this exchange, one thing is absolutely clear. Senator Adam Schiff exposed a nominee who refuses to give the American people straight answers on the most fundamental constitutional issues. Schiff pressed him on the Emoluments Clause, one of the clearest protections the founders created to stop foreign influence. Yet, when asked whether accepting multi-million-dollar gifts from foreign governments would violate the Constitution, the nominee hid behind evasions and claimed he couldn't say. That alone should concern anyone who believes the presidency should never be for sale. Schiff then walked through landmark cases protecting same-sex marriage, privacy, and equality. And again, the nominee refused to say whether those rights are legitimate, even though he openly agreed with Loving v. Virginia when it benefited him personally. Schiff exposed a pattern. He's willing to affirm rights when they apply to him, but not to millions of Americans whose equality is still under attack. The most alarming moment came when Schiff confronted him on Moore versus Harper and the dangerous independent state legislature theory. Schiff laid out exactly how this theory could empower state politicians to overturn election results, and the nominee still refused to say whether courts should stop an attempted subversion of democracy. That silence matters. It signals how far some nominees may go to weaken voting rights and destabilize our electoral system. Senator Schiff made it clear why this kind of judicial ambiguity is dangerous. When a nominee cannot commit to basic constitutional protections, the American people cannot trust them to defend democracy when it matters most. If you want more sharp, honest coverage of critical Senate and Congress hearings, subscribe to Crossline Politics and stay informed.